Hello, everybody. My name is Anne Deschamps, and I am the director of the Mid-Atlantic ADA Center. And I am joined by my colleague, Nancy Horton, who is the associate director of the Mid-Atlantic ADA Center. And today, Nancy and I are going to have a conversation with all of you about the employment jumble, puzzling over the ADA and other laws. We frequently get a lot of questions about not only the ADA, but about other employment laws and the overlap connecting. So slide 13. So we are going to provide an outline of a few federal employment laws. Title I of the Americans with Disabilities Act, Section 501 and 503 of the Rehabilitation Act, the Congressional Accountability Act, the Genetic Information Non-Discrimination Act, the Age Discrimination in Employment Act, the Family Medical Leave Act, the Civil Rights Act, the Pregnant Workers Fairness Act, the Vietnam Veterans Readjustment and Assistance Act, and the Uniformed Services Employment and Reemployment Rights Act. So you can see where we got the title, the employment jumble. Finally, the best part, we have a lot of resources for you because no doubt we can only touch on these really, really briefly over the next hour, and you may have more questions, and we have resources for you. Next slide, please. Well, let's start with our all-time favorite, the Americans with Disabilities Act. What employers are covered by the ADA? Well, state and local government agencies and private employers with at least 15 or more employees, employment agencies, labor unions that have at least 15 members, and joint labor management companies with apprentice and job training programs. So, hey, what about the federal government? Slide 15. Nancy, it's your turn.
Let me unmute myself here. Yes, what about the federal government? This is a question we get a lot in our ADA center and probably in ADA centers around the country. So the federal government, a lot of the parts of the federal government are not covered by the ADA. But the executive branch of the federal government is covered by the Rehabilitation Act of 1973, a much older law than the ADA. The ADA, especially certain parts of the ADA, are very much modeled after the Rehabilitation Act. And this is a law much like the ADA. It prohibits disability discrimination. It's really a civil rights law like the ADA. So applicants and employees of all the federal executive agencies, that's the Department of Agriculture to Commerce, all the way down to Veterans Affairs and all the others in between there, are covered by Section 501 of the Rehabilitation Act, which again is very much like Title I of the ADA. However, affirmative action is required, affirmative action in relation to workers with disabilities. Agencies need to make some efforts to recruit and hire and retain workers with disabilities. Now, the contractors of federal agencies are covered by another section, 503, Section 503 of the Rehabilitation Act, which also requires affirmative action in relation to workers with disabilities. Affirmative action is something that the ADA does not require. So this is a little better for workers with disabilities. These agencies are, these contractors are supposed to, again, make efforts to recruit, hire, and retain workers with disabilities. There's an office called the Office of Federal Contract Compliance Programs, or the OFCCP, which regulates and deals with Section 503. Now, the legislative branch of the federal government, which is also covered by the ADA, Congress covered themselves when they passed the ADA in 1990 under Title V, but a few years later, they implemented the Congressional Accountability Act, which applies the provisions of Title I of the ADA to the Congress. So this would cover applicants and employees who work for the House of Representatives, the Senate, and other agencies that are associated with Congress, like the Library of Congress, the Capitol Police, the Office of the Architect of the Capitol, and other agencies. Now, the judicial branch of the federal government isn't covered by these laws. They do have a policy, however, in the U.S. courts to accommodate people with disabilities who are participating in federal court proceedings and activities. So we get a lot of questions about the Rehabilitation Act. So we like people to know that there is coverage there, in many cases very similar to what we see under the ADA, but there are some important distinctions. So on our next slide, number 16, we want to talk a little bit about who's protected under these laws that we've just talked about, including Title I of the ADA and the Rehabilitation Act. These two laws share the same definition of disability. It includes an individual who has a physical or mental impairment that substantially limits one or more major life activities. Major life activities are some of our basic physical and mental kind of functions, like walking and talking and hearing and seeing and thinking and learning and concentrating, things of that nature. The definition also includes anybody who has a record of such an impairment. There might be a person who used to have cancer and now doesn't have cancer anymore, but they do have this record of this very substantially limiting impairment. And if they're discriminated against on that basis, they would be protected. These laws also protect individuals who are what we call regarded as or perceived as having a disability. So again, this is aimed at really protecting people from discrimination based on rumors and assumptions and these sorts of things, and people who may experience discrimination. And because we're talking about employment, we have to also include that people who have disabilities need to be qualified for jobs. They have to be able to perform the essential functions of jobs. They have to be qualified for the jobs they are in or the jobs they are applying for to be protected under the ADA. So moving along to our next slide, we want to talk a little bit about reasonable accommodation. Again, we're going to talk about Title I of the ADA and the Rehabilitation Act sort of together here because they're very similar in how they view this issue of accommodation, which is any kind of a modification, adjustment, allowance, or provision, something that's provided by an employer that facilitates an equal employment opportunity for a worker with a disability. And this is throughout any part or any phase of employment. This means when somebody's applying for a job, when they're performing their job duties, or when they need to access or participate in the benefits and privileges that go along with a job. So a reasonable accommodation is one that doesn't create any kind of a significant difficulty or expense for the employer. That's what we call undue hardship under Title I of the ADA and similar under the Rehabilitation Act. So that's for a lot of workers with disabilities, reasonable accommodation is a very important piece of these laws that enable them to work. So moving along to our next slide, We just want to remind folks that, who is entitled to reasonable accommodation, again, is a qualified applicant or an employee. They could be full-time, part-time, seasonal employees, temporary employees, work there 1 day or 10 years, doesn't matter. They're a qualified individual with a disability or a record of a disability. Remember those 3 different sort of categories of that definition. Somebody who right now has a substantial limiting impairment, somebody who used to have that. These are the individuals who are entitled to reasonable accommodations. Individuals who are regarded as having a disability are protected from discrimination, but they're not entitled to reasonable accommodations because, remember, they don't really have disabilities.
Yeah.
They're simply being regarded as having disabilities. So it's the discrimination that sometimes these folks might encounter, and they would be protected on that basis. So that's a real quick run through some of the very basics of Title I and the Rehabilitation Act.
So, Nancy, essentially, the Rehabilitation Act of 1973 laid the groundwork for the Americans with Disabilities Act in 1990. So a lot of the concepts that are laid out there, as you said, we see in the ADA. So they're very similar, with the exception of the affirmative action part of the Rehabilitation Act, as far as the employment provisions.
Exactly. They're so similar, other than the affirmative action piece and certain sort of procedural things about how workers would proceed if they felt like they were experiencing discrimination, which is different under the ADA and the Rehabilitation Act. But these core concepts and principles are so similar. They're so much the same, really, that you can consider even court decisions and case law and things to be meaningful from one to the other.
Which is, and that's exactly why I brought that up, because when the ADA passed in 1990, it wasn't as if these concepts were brand new. They had, years and years and years of, legislative precedents being set. So we were familiar, at least the federal government was familiar with the implementation of things like reasonable accommodation, for one. So.
Absolutely. And in addition, another part of the Rehabilitation Act, which we didn't mention because it's not really directly about employment, but Section 504 of the Rehabilitation Act applies to not contractors, but funding recipients, organizations that receive financial assistance from federal agencies are subject to Section 504, which again, a lot of the ADA modeled after that. So funding recipients since the 70s, which includes many state and local government agencies, which are also covered by Title II of the ADA, and other private organizations that receive financial assistance. We're very familiar with these concepts, reasonable accommodation and non-discrimination and things like that. So yes, when the ADA was passed, it wasn't brand new for a lot of covered entities. For some, it was, but others, it was very familiar because of the Rehabilitation Act.
Yeah, and I'm glad you brought that up about Section 504, because that can be super confusing. We have federal government agencies, mostly here in DC, but all over. And then we have federal government contracting agencies that have contracts with the federal government that are covered by 503, and they're subject to the 503 requirements. And then a third category is recipients of federal funds. So that's 3 different categories, all under the Rehabilitation Act. And again, lots of overlap in the Venn diagram that is the Rehabilitation Act and the Americans with Disabilities Act. And I'm glad we've spent the first 19 minutes of the webinar on this, because I think it's really important. They are definitely distinct, different laws. However, of all the ones we're talking about today, they really have the most in common, particularly including the core concepts, which is what we usually spend most of our time talking about, whether we're doing training or technical assistance. So next slide, please, slide 19. So let's dive into those other laws. Well, we have the Genetic Information Non-Discrimination Act of 2008, otherwise known as GINA. And this passed, 2008 was a big year. That was when the ADA Amendments Act passed, and there was a clarification of the definition of disability. But the Genetic Information Non-Discrimination Act also passed in 2008. And that covers employers, the federal government. It covers state and local governments and private employers with 15 or more employees, employment agencies, labor unions with at least 15 members, and joint labor management. Next slide. Oh, there we go. Who does GINA protect? It protects all employees and applicants, and it prohibits discrimination based on genetic information about an individual's genetic tests, the genetic tests of an individual's family members, and an individual's family and medical history. So this includes everything related to employees, obviously, that's what we're talking about, employment, but also in health insurance coverage, which comes under employment as well. And this is a big deal when it comes to genetic information, because with the advances of technology, of course, as we've moved in from the 90s to the 2000s, we started to be able to find out all sorts of information based on our family history and background about diseases and inherited traits that we can find out now a lot more information than we used to. And that is all in our health records and can potentially lead to discrimination, hence the need for GINA. Okay. Next slide. All right, Nancy, I'm going to turn it back to you for the Age Discrimination in Employment Act of 1967, a long time ago. We're going from 2008 to 1967. Okay.
Yes, we're really jumping around here.
We are.
Yeah, this is a law that again, it's been around a long time, 1967. Still, we find that some people are not really aware of it. Employers that are covered include private employers, but they have to have at least 20 employees, not the 15 that we often see in some other laws, but at least 20 or more. State and local government agencies are covered regardless of how many employees they have. So again, a little bit different than some of the other laws. Employment agencies are covered. Labor unions, if they operate a hiring hall, obtaining workers for employers, or they have at least 25 members. So again, that's a little different here with the ADEA, age discrimination, and the joint labor management committees that often operate apprenticeship programs and job training programs are covered here. So who's protected? Applicants or employees who are 40 years old or older. I guess in 1967, that was old age.
40? 40? Really?
40 years old or older, protected from age discrimination. Congress decided that, there was a lot of forced retirement based on age, and older workers were sort of being, put out to pasture, and that's not necessarily good for individuals or families or employers or the economy as a whole. And so passed this act in 1967. So one of the reasons that we really want to talk a little bit, just a kind of an awareness level about some of these other laws, which are, really outside our area of expertise, but what we often find sometimes is that people feel like they're being discriminated against on more than one basis.
Mhm.
It's not necessarily disability or age or something else. Sometimes people feel like there's a bit of a jumble there. They're being discriminated against, maybe based on their age and their gender and their race and their disability or something. And so it's good to just have a little bit of awareness that there are a lot of laws out there, and this one's been around for a while, so it itself is now an older over 40.
It's covered by its own law.
Yeah. So excuse me, moving on to our next slide. This is another law that we tend to get where we see some overlap, confusion maybe sometimes, because there can be some interaction, even though the FMLA is very different from the ADA, but in several ways. The FMLA it's not a civil rights law. It's really a law that's designed to allow workers to take some time off, just like it sounds. It's about leave. It's about taking time off. It's a law that's designed to kind of support a work-life balance by having people have some job-protected time off. So what employers are covered by the FMLA? Private employers, if they have 50, that's 50, not 15, 50 or more employees, as well as federal, state, and local government employers. So all government employers at every level are covered by FMLA. Employees have to be eligible to take leave. They have to have worked for a covered employer for at least 12 months. They have to have at least 1,250 hours of service with the employer during the 12 months before their FMLA leave starts. And they have to work at a location where the employer has at least 50 employees within a 75-mile geographic area there. So that's eligibility for leave. And on our next slide, we can see what people can use leave for and how much they can take. If employees are eligible for FMLA leave, they can take up to 12 work weeks, and that's a term that the Department of Labor uses because your leave is based on how many hours you work in a week. So if you're a typical full-time employee, your work week is 40 hours. If you work 35 hours, that's your schedule. Routinely, you work 35 hours a week, that's your work week. So when you take FMLA leave, you can take up to 12 work weeks, whatever that means for you, in a 12-month period for any FMLA reason. And we'll talk about what the reasons are here in just a second. Eligible employees can take up to 26 work weeks of military caregiver leave during a single 12-month period. Now, these two different types of leaves can be combined, but the total can never exceed 26 weeks total. So the reasons, and this top reason is one of the reasons we often get some overlap with Title I of the ADA. One of the reasons you can take leave under FMLA is to address a serious health condition, which might be your own serious health condition or a serious health condition of an immediate family member that you need to participate in that for them. So again, serious health condition is not the same as a disability necessarily, but sometimes it is. It could be a serious health condition, could also meet the definition of disability, or vice versa. So people might have protections under both Title I and FMLA that can that can happen. Other reasons that people who are eligible might be able to take leave under FMLA is certain reasons related to a family member's military service or for the birth of a child or placement of a child for adoption or foster care. So this last point on this slide is something that often comes up. Very often leave under the FMLA is unpaid. You're not entitled to paid leave. It can be used in conjunction with paid leave if you have paid leave that you're entitled to under your employer's policy. You might get some paid leave. For example, let's say you need 6 weeks off for a reason under the FMLA, maybe your own serious health condition. You have on the books, you have 2 weeks of paid sick leave under your employer's policy that you can use for that. So you might get paid for 2 weeks of your 6 weeks of leave and not paid for the other 4 weeks. Under FMLA, you'd be entitled to that job protection. So you'll be able to come back and be returned to your job. So these kinds of, paid leave can sometimes be, run concurrently with the FMLA, and people can either choose to do that if their employer does it that way, or the employer can require it to be concurrent. So you use up your paid leave if you have that, and then if that runs out, it's typically an unpaid leave. Again, the real point of FMLA is to really just protect people's jobs so that they can return to work after taking some time off. This is the Department of Labor regulates the FMLA. So I think on our next slide, I think Anne is going to talk a little bit about the Civil Rights Act.
Right. And before I do, I meant to say at the beginning, my bad, please go ahead and keep continuing to type questions in the Q&A. And Nancy and I will leave enough time at the end of our presentation to go back and answer questions. So I see there are some questions there, and we will have a chance to get back to them after we finish presenting this menu of employment laws. Okay. Moving on to Title VII of the Civil Rights Act of 1964, the other precursor to the ADA, besides the Rehabilitation Act, between the Civil Rights Act and the Rehabilitation Act, we have the foundation for the Americans with Disabilities Act. So the Civil Rights Act, otherwise known as CRA, prohibits discrimination based on race, color, religion, sex, and national origin, and says that employers must reasonably accommodate an employee's religious belief or practices unless it would cause an undue burden. And there we see the word undue burden again, which we have seen before in both the ADA and the Rehabilitation Act. The Pregnancy Discrimination Act of 1978, otherwise known as PDA, amended the Civil Rights Act to clarify that sex discrimination includes discrimination based on pregnancy, childbirth, and related medical conditions. And then in 2020, the Supreme Court decision clarified that sex discrimination includes discrimination based on sexual orientation or gender identity. So you see, Nancy, from 64 to 78 to 2020, the Civil Rights Act is keeping up with our times here. So next slide, please. Okay. What employers are covered under the Civil Rights Act? Well, the federal government is covered, state and local governments and private employers with, again, 15 or more employees, employment agencies, labor unions, and joint labor management committees are covered under the Civil Rights Act. All right, speaking of pregnancy, which is we saw under the Civil Rights Act, let's move to the Pregnant Workers Fairness Act of 2022, Nancy, PWFA.
Yes, the PWFA, the Pregnant Workers Fairness Act, is a very new law. I mean, even though we had this some protection under the PDA, the Pregnancy Discrimination Act, that sort of amended Title VII. But on our next slide, which I think is number 26, so we're up to slide 26. This is a fairly new law. This is the ink is barely dry on this law on the books here. This is just last year, 2022, and this is really an interesting law because it really expands some protections and provisions for pregnant workers. Employers must provide reasonable accommodations. There's that concept again to a worker's known limitations related to pregnancy, childbirth, or related medical conditions, unless it would cause an undue hardship. So a lot of language and the concepts that we're familiar with here, especially in ADA land, Title I land. However, under the PWFA, the limitations related to pregnancy, childbirth, other medical, related medical conditions don't have to be disabilities. They do not need to rise to that level and meet that definition of disability under the ADA. Pregnant workers who might have had conditions, impairments that resulted from pregnancy that did rise to the level of disability have been protected under Title I of the ADA. But pregnancy may give rise to limitations that really don't rise to that level of really meeting that definition of disability. Now, under this new law, they would be entitled to reasonable accommodations from employers. So this really expands some rights for pregnant workers. So on our next slide, number 27, what employers are covered by this new law? Again, pretty broad coverage here. Federal government is covered. State and local governments and private employers are covered if they have 15 or more employees. Employment agencies are covered, and labor unions are covered if they have at least 15 members. So that is just very briefly on the new law, PWFA. And I think on our next slide, 28, I believe we're up to slide 28. We're going to talk about a couple of other laws here. The Vietnam Era Veterans Readjustment Assistance Act of 1974, otherwise sometimes known as VEVRA. This covers federal contractors. And, we talked a little bit about federal contractors earlier when we talked about Section 503 and how federal contractors are required to practice affirmative action in relation to workers with disabilities under Section 503. This law, VEVRA, and again, much older law, 1974, it prohibits federal contractors from discriminating against veterans who have served honorably. And this includes veterans with disabilities, but it's not limited to veterans with disabilities. It's not really about disability. It's about veterans. And again, contractors are required to practice affirmative action here, but not in relation to workers with disabilities, in relation to veterans. So they have to make some efforts here to recruit, hire, promote, and retain veterans. And this VEVRA does mention reasonable accommodation for qualified veterans with disabilities in this law. So again, going back to 1974, when federal contractors had this obligation to provide reasonable accommodations for qualified veterans with disabilities. So this is an important law for veterans.
Yeah, so Nancy, it seems like that the federal government in the 70s with the Rehabilitation Act and with VEVRA really made an effort to guide federal contractors that they needed to hire people with disabilities and veterans with and without disabilities, and set that accommodation requirement.
Yes,
And
I think really,
70s.
yes. Yes, even in the 60s and 70s and really following, we did see a lot more of these kind of laws that were really aimed at getting people back into the workforce or into the workforce, people who had sometimes been sort of viewed with paternalism or other approaches, and so we need people to be able to go to work. And of course, a lot, veterans and people with disabilities and women and people of all kinds of races and really want to work, right? Most people do want to work for their own sake, for their families, for their communities. So I think we did see a real development of these kinds of laws back starting, especially in the 60s. Now, this law here on slide 29 was 1994. So this is, a little bit after the ADA was passed. But again, this is really about, service, military service and veterans, the Uniformed Services Employment and Reemployment Rights Act. This is designed to, a lot of this is aimed at getting veterans back into the civilian workforce once they've separated or retired or whatever the case may be. And this really is intended to protect either past service members, current service members, or even potential service members from discrimination based on uniform service. So even, if a worker says, gee, I think I might join the National Guard, their employer shouldn't be discriminating against them based on, they don't want to deal with that or something. So there are some rights to reemployment in civilian jobs following honorable service. It talks about veterans who may have been disabled in their military service. And there's some language about reemploying them in comparable jobs if their disabilities that they obtained in their military service renders them unable to return to their previous jobs. This is kind of a concept that those of us in Title I ADA land would say, gee, that sounds like reassignment. That's a form of reasonable accommodation. Sometimes when people are not able to continue in the jobs they're in, they've acquired a disability or something of that nature, and they might be reassigned. You might be able to reassign them. So there's a sort of a similar concept here in the USERRA, the Uniformed Services Employment and Reemployment Rights Act. That is a mouthful. So
yeah, that is.
Yeah, it is. Say that 3 times fast. And the coverage here is extremely broad. Almost all employers in the country are covered, regardless of size. There's no minimum number of employees. Private employers are covered, and government at every level, from local to state to federal government agencies, are all covered by this law and need to make these, efforts to reemploy honorably veterans who've served honorably. So those are a couple of laws that are very important for veterans, including veterans with disabilities, but not only veterans with disabilities. And I think that we have maybe one more slide that Ann's going to talk about state laws.
Yes. I think, wow, veterans have a lot of coverage within different laws. So working out which laws apply in their specific situations is certainly a challenge.
And it might be more than one.
Yeah, exactly. That's what I was thinking, especially as you talked about the last 2 laws. All right. So don't forget about your state laws. Some state or even local laws protect people based on additional factors, cover smaller employers like 2 or more employees, and provide for greater remedies. And whichever law, when it comes to anti-discrimination law, whichever law provides the most protection is the one that applies. And you want to check with your state's attorney general or your Fair Employment Practices Agency to get more information on your state laws. And before we start taking questions, Nancy, you put together, I won't say we, you put together an amazing list of resources that I just want to go through really quickly. And I'm not going to spend a lot of time on the different resources because you have them, they're there. You can download the presentation from our website and the resources there, but I do want to take a look at them. So slide 31, please. You have the Equal Employment Opportunity Commission, and you can find at eeoc.gov with information and enforcement about enforcement of ADA Title I, GINA, ADEA, CRA, lots of initials here, Title VII, PDA, Pregnancy Discrimination Act, and Title VII of the CRA, Civil Rights Act, and the PWFA. Information on 501, any kind of workers should contact the agency's EEO office within their department if they have the questions. In fact, I just did a training right before this webinar with one of the EEO offices from one of our federal agencies. So the Office of Congressional Workplace Rights. Who knew there was an Office of Congressional Workplace Rights? OCWR.gov. They are in charge of enforcing the Congressional Accountability Act, so you can get more information there. Next slide, please. You have the Department of Labor, which has within there the Office of Federal Contract Compliance Programs, the OFCCP, and you have Section 503 of the Rehabilitation Act and VEVRA under the Department of Labor. You have USERA and VEVRA under the Department of Labor Veterans Employment Training Services. So you sorted through all this for us, so we don't need to go searching around. Thank you so much, Nancy. And then under the Department of Labor, again, the Wage and Hour Division, you have FMLA. Next slide, please. So again, under the U.S. Department of Labor, under the Office of Disability and Employment Policy, we have the Job Accommodation Network, AskJan.org, which is a fabulous, fabulous resource on accommodations. And you saw how much reasonable accommodation came up within the Rehabilitation Act and obviously within the ADA and other laws. The Office of Disability Employment Policy also funds the Employer Assistance and Resource Network on Disability Inclusion, which has so many resources for employers on including people with disabilities in the workforce. It really is a great website with lots of information. And then we have the Partnership on Employment and Accessible Technology, another website with a lot of wonderful resources, and that's peatworks.org. Okay. Next slide, please. We have state vocational rehabilitation agencies. And again, state vocational rehabilitation agencies' mission is to help get us back to work. And they have a lot of resources. And if you go to rsa.ed.gov/about/states, you can find a link to your state rehabilitation organization. Centers for Independent Living, another fabulous resource. And there is a link for, if you go to ilru.org, and you can click on from the front page and get to the listings of the centers from the different states and access your local Center for Independent Living. And then, of course, we have disabilityin.org, which has been around for a long time. I remember when it was, the President's Committee on Employment for People with Disabilities is now the Office of Disability Employment Policy. This was the the Business Leadership Network, the U.S. Business Leadership Network that is now known as Disability:IN for those people like Nancy and myself who have been around for a little while. Okay, So before we go to our last slide, I wanted to take a few minutes and maybe answer some of the questions. Nancy, I don't know if you've had a chance to look at any of the questions there in the chat. I actually would like to go back to one that Shaylee, I'm sorry, I'm probably pronouncing your name wrong, Shaylee Collins submitted, and she asked, would increased costs for insurance due to an employee's past cancer diagnosis be considered undue hardship according to the ADA? Nancy, do you want to respond to that one?
There, let me unmute myself. It might be unlikely to be an undue hardship for an employer. You can't make judgments about undue hardship in the abstract in any event. The thing about insurance is that the ADA has what's sometimes termed the safe harbor for insurance, which means that they can sort of operate in that traditional way of assigning risk factors to people based on statistics, as opposed to looking at them as individuals, which is what we have to do under the ADA in almost every other way, right? We don't just lump them in a group and say, yeah, you're all the same.
Oops.
Insurance can sort of do that, to discriminate against somebody because they think that maybe their premiums are going to go up or something like that. And Title I talks about those kinds of issues. But as we all know, with the cost of healthcare, it can certainly get to be a factor. I think you really just have to look at situations. But Title I definitely says, employers really are not supposed to just discriminate based on, especially if it's just speculative.
Yeah, absolutely. Now, Karen needed some clarification back when we were talking about who is entitled to reasonable accommodation. And Karen, feel free to type in Q&A again if this is not the correct question, but I think she wanted clarification about the statement you made about individuals who are regarded as having a disability are protected from discrimination, but not entitled to reasonable accommodation. Can you explain that a little bit more, Nancy?
I can try. I mean, that, again, that so-called prong of the definition about being regarded as having a disability was always really intended to protect people based on attitudes, assumptions, and things of that nature. So the idea there is that these are people who don't have disabilities. They might have some minor impairment that people then use as a basis for their perception and their discrimination, but it isn't really a substantially limiting impairment. It's not really preventing or significantly, impacting a person's ability to talk or walk or learn or any of those things, but there's just a little something that people are maybe using as a basis for discrimination. So they're to be protected under the ADA because of that. Or they might not have any impairment whatsoever. There might have been a rumor that they have something, or just an assumption that they have, HIV or psychiatric disability, just something that people then discriminate, but they don't actually have a disability. So therefore, they don't need an accommodation, because an accommodation is designed to mitigate disability. So I don't know if that helps.
No, I think that makes sense. And hopefully that answered her questions.
We kind of see a similar issue with the association provision, which isn't something that we talked about, but we sometimes get questions about that. That's another group of people who don't have disabilities, but who could be protected under the ADA from discrimination if they have, say, a child or a spouse or with a disability and they're discriminated against on that basis, or they do volunteer work for a disability related organization. They're protected from discrimination, but again, they don't have disabilities themselves, so they're not entitled to accommodation.
Yeah, and that was a question we got a lot during the pandemic when parents of kids with disabilities needed to take time off and they wanted to request it as a reasonable accommodation, but they did not need the reasonable accommodation. And they thought it fell under their association with a person with a disability because their son or daughter had a disability, but that is not a reasonable accommodation issue. And Charlotte, the slides are available on our website, so you can download them there. A question, and I don't know the answer to this, I don't know if you do, Nancy, but we could try. Is VEVRA limited to Vietnam era veterans only? Or does
I do not believe so. I think it's any veterans.
Okay, great.
Yeah.
Regarding the number of employees private employers are required to have in order to make them compliant with the ADA, do these include part-time, seasonal, and temporary employees?
It certainly could. The way you count employees, in a lot of these laws, there's some nuances, and when it comes to contractors, the value of their contracts, and there are some nuances that we didn't get into the weeds, and we didn't have time to get into the weeds. But under the ADA, and this is the same under Title VII of the Civil Rights Act, it's 15 or more employees for each working day in each of 20 or more calendar weeks in the same calendar year or the previous calendar year to when the discrimination was alleged. So it certainly, so it includes everybody, and you just have to count. It doesn't have to be the same 15 employees, right, all the time. It's, do you have any 15 employees on a given day for at least 20 weeks? And that's not even half the year. So,
or at least 20 weeks. Okay.
Wow. Yeah. So when it's sometimes when it's sort of on the cusp, you have to really get into those weeds and really count up employees and who counts. Partners don't count, and certain people that they're not really employees. It can get a little bit tricky. A lot of employers, it's very clear that they're absolutely covered or that they're absolutely not under the ADA, but sometimes you do need to get into those details.
And here's another common question that we get too. Is morbid obesity considered a disability protected under the Civil Rights Act or the ADA?
I hesitate to speak to the Civil Rights Act because it really is, not our area of expertise. I don't think that it is a protected class under the Civil Rights Act. It could be under the ADA. The courts are not really in agreement on this. They're a little bit split on how they view just obesity without an impairment, like hypertension or something, back impairment or something. The EEOC views morbid obesity as an impairment, however. So if it substantially limits a major life activity like walking or sitting or climbing or something, it certainly could be a disability, but you kind of have to follow that definition through and look at those factors. Some courts do not even consider it an impairment. The EEOC does. They seem to. So that's a very fuzzy answer, not much of an answer.
No, and it's the answer that the most common answer to any ADA question is it depends. So I think that's a great note to end on. Thank you so much for joining us. We are the Mid-Atlantic ADA Center. Please, if we didn't answer your question, you can call our 800 number, 800-949-4232, or 301-217-0124. And we will answer your question. You can also go to our website is adainfo.org. And you can also email adainfo@transcend.org. And Nancy, I'm so excited. We are going to be back at the end of November after Thanksgiving, and register to do our next webinar on remote work as a reasonable accommodation. No blankets allowed. From 2 to 3 on November 29th, 2023. So we hope you'll join us for that. But thank you very much. Oh, look at me, right on the nose, 3 o'clock. Thank you so much for joining us today. Nancy, I don't know if you want to say anything else before we leave.
I would add my thanks to that. Thank you to all of you who joined us. Thanks to Braden and Emily and our captioner and everyone else who helped us bring this information to you today.
Yes. Thank you very much, Braden, Emily, and Captioner. All right. Have a good rest of your day.